Hey everyone, we're gonna do things a little bit differently today. Okay, so today I want to tell you about a consultation that I had that I think captures something I wish more people understood about immigration law. Most people think immigration cases are about filling out forms. They think the lawyer's job is to know which form to fill out, which form to file, what box to check, what fee to pay, and where to mail a package. And of course, forms matter, deadlines matter, filing fees matter, but that's not where most cases are won. The real work begins long before anyone fills out any forms. The real work is figuring out what the case is actually about. When clients come to see me, of course, they know what happened to them, but they don't always know which parts of what happened matter legally. They don't always know what the government needs to see. They don't always know which facts strengthen the case, which facts need to be corroborated. They don't know that they've had experiences that they've been quietly carrying for so long that may actually become the heart of the case. And that's what this consultation was about. A couple came to see me about a 601A waiver, and I know you're most likely not an immigration lawyer. A 601A waiver is sometimes called a provisional unlawful presence waiver. But I don't want to begin with a technical definition because that's not how the consultation began. It began with a family, a husband without legal status, a United States citizen wife, and a young daughter, a life built here, and a terrifying possibility. If the husband left the United States for his consular interview, he could trigger a 10-year bar before returning to his family. 10 years. Imagine trying to explain that to your child. Imagine putting your marriage, your family, and your future on hold because the law requires you to leave first in order to ask permission to come back. And that's the reality that many families face. So the waiver is not simply paperwork. It's the family's opportunity to demonstrate that separating them would cause extraordinary, exceptional hardship to the United States citizen spouse. And that's the legal framework. But it's not yet the case. Most people think hardship means one thing: money. He helps pay the bills. He supports the family. He helps to take care of our daughter. And yes, those facts matter, but by themselves, they're rarely enough. It's because every family suffers when someone is separated. So what makes your wife's suffering or your spouse's suffering exceptional, extraordinary? Every spouse would experience loss. Every child misses a parent. The real question is different. What makes this family's hardship different? What makes it deeper, extraordinary, unusual? What makes the hardship legally sufficient? And that's where the investigation began. As I listened to the wife, I wasn't simply listening for facts. I was listening for patterns. She spoke about her fear of losing her husband. She spoke about their daughter. She spoke about what life would look like if he could not return. And many people would stop there. I didn't. Because sometimes the most important evidence is not the first thing a client tells you. Sometimes it's something mentioned almost in passing because to the client, it's simply part of life. She mentioned something else. As a child, she had been separated from her own parents. And suddenly, I wasn't just hearing fear about the future. I was hearing an old wound being reopened. And that changed the case. If her husband were forced to leave, she would not simply experience another difficult immigration process. She would relive a childhood trauma. She could watch her own daughter experience the very kind of separation that had shaped her own life. That's no longer an ordinary hardship case. That is a different story. And this is why I believe immigration consultations are investigations. The client thought the case was about her husband. Legally, the center of the case was the qualifying relative, her. And so my questions changed. What happens to you emotionally, psychologically, as a mother? How does your husband stabilize your life? What's happened? What will happen if he's gone for months or even years? Those questions uncovered the case that the law actually required us to prove, not by exaggerating, not by inventing hardship, but by discovering what was already there. Immigration law has this strange relationship with suffering. People suffer usually privately. But if hardship is invisible, we as lawyers have to make it visible. And sometimes that means affidavits, records, psych evaluation. Sometimes it means helping someone tell a story they never realized was legally sufficient or significant. And that's one of the most important lessons from this consultation. Strong cases are not built by asking for sympathy. They're built by carefully documenting why this particular family with this particular history would experience this particular hardship. And once we recognized the real issue, everything changed. We stopped simply collecting documents. We started building a hardship narrative. We asked what she had already survived in the past, what emotional burdens she carries today, how her husband's presence affected her ability to parent, what another separation on top of that would truly mean. And that's where legal analysis becomes human. See, the forms will ask questions, but the forms will never discover the story. The lawyer has to do that. Clients often don't know what matters the most. Sometimes they don't even recognize their own experiences as evidence. An experienced immigration lawyer listens for legal significance hidden inside ordinary experiences. And that's what happened here. The strongest evidence at first was invisible. It was not sitting in a folder. It was not in a tax return or a receipt. It was a childhood experience of separation. A fear that history might repeat itself through the next generation. And that became the heart of the case. Now, of course, none of this guarantees success. A compelling story doesn't automatically produce an approval. Honesty matters. Evidence matters. Timing matters, and strategy matters. And that's why I wanted this family to understand something very important. Do not treat your case like a form. Do not treat it like a checklist. Do not assume that because you're suffering and your suffering is real, the government automatically understands it. Our job is to uncover it, to organize it, corroborate it, and to present it honestly. People sometimes ask me, what makes an immigration case strong? I rarely begin with the form number. I begin with the facts, and not just the obvious facts, the hidden facts, the facts the client almost forgot to mention, the facts they never imagined could matter. Because sometimes the most important evidence in an immigration case is invisible until someone asks the right question. And that's why I don't begin with the forms. I begin with the questions. Thank you for listening. I hope you enjoyed this format.